We're going to get back to the Beecraft Patriot Attorney, and we're going to keep hammering home on this point. I find it very interesting, the dialogue going back and forth between Beecraft and the supporting compelling evidence that is being presented by these gentlemen who created this memorandum of law. It's a very beautiful thing. A lot of people have asked me on Facebook, why won't you share it? The last time I tried to share this memorandum of law, I was blocked on Facebook for 30 fucking days. So that ought to tell you something. So I will give you the address to where this document is. It's called Memorandums of Law. It's in section 05.xxx. And it is https://sedm.org. And I have in the past attempted to share this on Facebook and immediately was banned for 30 days. And I'm going to tell you something right now. When you go to share information like this and you are blocked and scrutinized for it, it tells you that you're onto something, all right? And so people have asked me, hey, your information that you disseminate to us is very important. Would you please stop posting things about Biden and the rampant corruption? Because every time you do it, we're the people that are deprived of the information that you have to provide to us, and what you're finding in the literature. Many of us work and we don't have the time to go look at all this stuff for ourselves, so we listen to your audio videos while we work. So I have refrained from posting things about the criminality and the actions of the people that are purportedly in office. Due to that fact, recently I found a great deal of information about Biden's laptop, Hunter Biden's laptop, and I went to share it on Facebook and was immediately banned for 6 days. Immediately banned. And the interesting thing is there were some other people that shared that information and did not get banned. So it's really, really funny. Feed is really scattered. That's no surprise. So again, we're going to get back to Beecraft. Facebook oftentimes comes back with a little message, even while I'm live, saying that my feed doesn't have a very good connection, which is preposterous because I've got all the bars in the world that you can have that shows that I have perfect signal. So I don't know how to explain that. Don't want to sound like a conspiracy nut, but nevertheless, we're going to get back into Beecraft. As most attorneys do, you have added lots of heat and absolutely no light to the most important issue of citizenship. You have presented no facts directly pertinent to a private person or man not subject to the federal civil law, which derives from the legislatively foreign domicile of such party as required by Federal Rules of Civil Procedure 17b. All civil law cited must derive from the domicile of the party, which means no federal statutory civil law can be cited for those with a foreign domicile unless the party proves there was consensual, purposeful availment, which you have not proven. See the Internal Shoe case and the Foreign Sovereign Immunities Act, FSIA, Title 28 U.S.C., Chapter 97, citing foreign law against a non-resident with no purposeful availment is an abuse of the courts for political purposes in violation of the separation of powers. Number 2. There is no financial vested interest in the position you claim we have a vested interest in. The citizenship information provided to you for rebuttal is and always has been absolutely free. It would have to be offered for sale before there could be or is a financial interest. Hence, the statement that there is a vested interest is absolutely false and fraudulent. He's doing a negative averment here. The person, number 3. The person with a real vested interest is you, who benefits handsomely to the tune of tens of thousands of dollars when people are confused, arguing and have to litigate expensively to resolve the confusion. There is no financial incentive for attorneys to prevent conflict. In fact, and I'm ad-libbing here, conflict is exactly how attorneys get paid, ladies and gentlemen. They have no incentive to resolve an issue until the fact that you're absolutely broke, your credit score is shit, and they've fleeced everything from your estate and make sure that your children have nothing to see when you perish and pass on, okay? So lawyers aren't there to resolve conflict in any way, sense of the word, because they get paid based upon perpetuating conflict. And I've seen it firsthand in divorce cases where I've had people get a hold of me saying, hey, Derek, every month I have to go to some fucking bullshit mediation. Cost me $1,800 for 30 fucking minutes. And we've been doing this for 3 years now. What do? I said, call your attorney and tell him that you hate to inform him of this, but cattle prices are down, corn prices are down, you're broke, you don't have $1,800. And within 30 minutes, he receives a call because he leaves this message with the secretary of the law firm. Within 30 minutes, the lawyer calls and says, you know what, we'll have to reschedule later on down the road. I mean, if you don't have the money for it, we can't go into mediation. The administrator needs paid, I need paid, her lawyer needs paid, and if you don't have the money, I guess we just will postpone this. And he called me back just laughing. He goes, how did you figure that out? I go, it's really fucking simple. They get paid to constantly keep people in conflict. And the second that you tell them you don't have any money, they'll resolve the conflict because they don't want to be involved in it anymore because they're not getting fucking paid. Well, it wasn't more than 3 weeks later. He calls me up and he says, you're never going to believe this shit. I go, what's up? He says, the lawyers have reached terms of agreements for both parties to assent to, and they're saying that this issue is now resolved and all we have to do is sign. 3 years of bullshit mediation, and the one time that he says, I just don't have money anymore. I can't participate anymore. I don't have the financial wherewithal to give you guys $1,800 for a 30-minute meeting every fucking month. Don't have it anymore. All of a sudden, magically, the conflict is gone. We have resolution. We're proud to tell you we have resolution. You just need to come on down here and sign some documents and it's done, And he just laughed because that was the answer to keep, to end all this bullshit, which is really Baratrade. They keep it going because they have a financial interest in the conflict and they keep making money. And as long as you're not intelligent enough to figure out what they're doing, they're going to continue to do that to you. Okay. And a big disincentive to do so. You can't and won't act in a preemptive mode to resolve the conflict and ensuing litigation. The way to do that is to address all the issues raised in the why you are a national, state national, and constitutional but not statutory citizen. Hence, you perpetuate and protect a very profitable for you source of confusion on this subject. Remember, he's still addressing Mr. Beecraft, the attorney. You falsely accuse us of being a guru. A guru is someone that people trust or rely on for a specific subject matter. Yet, our member agreement specifically says that our members and readers are not allowed to trust any man, including us, to interpret the law and will only trust their own reading of the law. See for yourself. How is it even possible to be a guru without some measure of reliance on a man that is forbidden by your member agreement, by our member agreement? What have you been smoking? Or don't you even study the people and things you so presumptuously and ignorantly and foolishly criticize? 5. You state that the argument is baseless, and yet it is supported by the 200 pages of research that neither you nor anyone else in over 10 years of peer review has proven is incorrect in any particular. Even the last federal judge and U.S. attorney who received such arguments didn't disagree with with them and therefore agreed. We even showed you how to prove it incorrect. Answer the question at the end, section 20, without contradicting yourself. The rules of statutory construction or the statutes. You can't. The only person with a baseless argument is the one without evidence, and you haven't presented the evidence in the form of answers to questions needed to supersede or discredit our evidence. How about it? A list of errata of this document, and B, answer to the question in sections 20 that disprove your assertions. 6, you attached a memorandum allegedly proving that the U.S. is not foreign in relation to the states. Even the Corpus Juris Secundum Legal Encyclopedia disagrees with you. You are correct that the United States is not foreign in relation to a state domiciled citizen if you mean in a constitutional sense, but incorrect if you mean a statutory sense. That only further proves that you intend to perpetuate the confusion of statutory and constitutional context that is the source of all unjust, unconstitutional, and criminal power wielded by the corrupted federal courts. The issue of being legislatively foreign but not constitutionally foreign is already addressed. When are you going to rebut the above with answers and equally persuasive arguments rather than childish name-calling with the word nasty? Your response is the childish response of children. I win. I'm plugging my ears and I'm not listening to your answer. Meaner. If you want to talk with me again about this, you will have to bribe me for $250 per hour in your next planned legal emergency, because all I care about is money and not justice or social responsibility. We would expect much better of such an experienced and informed person. We value your feedback, and lots of people will read of your childish response on a public website. Is that the best you can do, my friend? By disassociating and removing us from your email list, you have abandoned rational debate, gone into default, and admitted that you are misleading people because you can't and won't rebut or defend the above issue with facts, and therefore admit they are correct per Federal Rules Civil Procedure 8b-6. He who abandons the battlefield of debate by refusing to participate is always the loser. If there were a good definition for nasty in the legal field, a word you used, it would have to be people who maliciously play word games and confusion of context, statutory versus constitutional, to steal jurisdiction they do not have. This turns the public trust into a sham trust, and officers of the public trust, such as attorneys, into thieves and deceivers. U.S. Supreme Court Justice Scalia agrees on this subject of what nasty means. The following information and memorandum exposes how this criminal abuse happens, and you know that if you address it, you and most judges would be powerless and penniless. Justice Scalia admitted as much in the last video above. Foundation of Freedom course. Let me see. Oh, I can't get that right now. When we want to talk responsibly with a legal professional such as yourself about this foundation of all the corruption in the legal field to prevent harm, they plug their ears because it butters their bread with stolen loot and can't be threatened. Disgusting. Our readers will hear about this abuse. Finally, if you are going to warn your readers about us, at least have the decency and integrity to give them benefit of both sides of the argument by providing a link to the following and telling them that you agree with it because you can't prove it wrong. Why you are a national, state national, and constitutional, but not statutory citizen. Here are some of the self-serving presumptions that Mr. Beecraft is operating under to pad the government's, and judges' pockets, which are provably false, and which have already been disproved elsewhere in the context of this exhaustive memorandum. That there is only one context for legal words, statutory. Hence, he only needs to examine the statutes and can ignore the common law and the Constitution on this subject. 2. That the constitutional and statutory citizens are equivalent. They are not. 3. That case law that pertains to the statutory citizens, such as what he offers in proof, is relevant to those not similarly situated within a foreign domicile, such as our members. This violates choice of law rule. Choice of law rules, Federal Rules of Civil Procedure 17b, Foreign Sovereign Immunities Act, FSIA, Title 28 USC Chapter 97, Rules of Decisions Act, Title 28 USC subsection 1652, Star Dicey's decisions on the subject of domicile, the rules of statutory construction and interpretation, and 4, the geographical United States used in the Constitution is the same as that used in federal statutory law. They are simply not. 5. That the jurisdiction of the judge is whatever he says it is, and that the Federal Rules of Civil Procedure that we cite do not constrain any judge's jurisdiction. Thus, we have a society of men and not law, which is tyranny and anarchy. 6. That's it. Okay, for federal form to make the application falsely presume a political constitutional status, while agencies receiving the form maliciously enforce and presume a statutory or legal status. These two things are mutually exclusive, and it can only be one or the other. This type of contradiction is what Orwell called double think or double speak. Number 7. That judges and attorneys can add anything they want to the geographical definition found in Title 8 USC Code, such as states of the Union, even though they are not expressly included and therefore purposefully excluded per the rules of statutory construction and interpretation. This is a receipt for communism and anarchy. If Larry B. Kraft, or any attorney for that matter, admits any of the above contradictions and the fraud they represent, he will have to admit that he has been misrepresenting the law and injuring his clients for most of his career. Hence, all he can present is 1, an immune response by refusing to talk about the above issue, 2, an attack on the credibility of the messenger and try to shoot the messenger, which is us, and 3, refusing to clarify the context and definition and context of specific words of art he is using to commit identity theft by equivocation. Judges do the same thing by calling arguments frivolous, but refusing to present evidence on the record proving the arguments are indeed incorrect. A finding of facts and conclusion of law, perhaps? In that sense, they are violating the separation of powers by acting in a political capacity where frivolous simply means you are a heretic that refuses to join the state-sponsored religion of false presumption, which presumption serves as a substitute for religious faith, and also violates due process of law. Such tactics are how judges and attorneys do risk management and protect their plausible deniability. This prevents them from having to defend themselves from a suit brought by clients or litigants they have injured in the past with their false presumptions, misinterpretations, and legal ignorance. The worst thing an attorney can do is admit that they are mistaken, so they seldom take any position on any matter and always defer to any and every judge they are in front of, like Jell-O that molds to fill any space. Are you beginning to understand why the only people Jesus got angry at were the lawyers? Father, forgive them, for they know not what they do. In addition to the questions later in section 23, below are the key questions. Mr. B. Kraft refuses to answer because it exposes his false and self-serving and unconstitutional presumptions about citizenship. 1. By national within federal law, are you sure you don't mean national of the United States per Title 8 USC subsection 1101 A22, or the common in the common in Perkins versus ELG 307 U.S. 325, 1939? If so, we agree with your argument, but you need to clarify this is the case to prevent the confusion you are causing. 2. Is a state domiciled party born anywhere in the country, America, included within the definition of national found in Title 8 U.S.C. subsection 1101A21? And if not, why not? 3. Is the state mentioned in Title 28 U.S.C. subsection 1101A21 legislatively but not constitutionally foreign because it is a lower case? 4. Specifically, what would a man with American nationality domiciled in a legislative foreign state, such as a state of the Union, be called within Title 8? 5. If you say such person would be a national and citizen of the United States at birth per Title 8 U.S.C. subsection 1401, then what would a citizen of the District of Columbia be called if not that in Title 8 U.S.C. subsection 1401? Citizens of the District of Columbia and of the constitutional states are not equivalent per the U.S. Supreme Court. The first section of the 14th Amendment, Article 14th Amendment, to which our attention is more specifically invited, opens with a definition of citizenship. Not only citizenship of the United States of America, but citizenship of the states. No such definition was previously found in the Constitution, nor had any attempt been made to define it by an act of Congress. It had been the occasion of much discussion in the courts, by the executive departments, and in the public journals. It had been said by eminent judges that no man was a citizen of the United States of America except as he was a citizen of one of the states composing the Union. Those therefore who had been born and reside always in the District of Columbia or in its territories, though within the United States, were not citizens. Slaughterhouse Case 83 U.S. 16 Wall 36 21 L. ED 394 1873. In his defense, we also talked with Mr. B. Kraft about this section. He recognizes the existence of state citizens just as we do, but differs on what they should be called within the federal statutes. He says that instead of calling themselves non-citizen nationals, they should simply call themselves American citizens. He says that even early enactments of Congress recognized the distinctions between statutory U.S. citizens and state citizens by calling state citizens American citizens or citizens of the United States of America. For an example of such an approach, government false argument. Statutory and constitutional citizens are equivalent. False argument. Constitutional citizens born within states of the Union and domiciled there are statutory citizens of the United States pursuant to Title 8 U.S.C. subsection 1401, Title 26 U.S.C. subsection 3121E, Title 26 U.S.C. subsection 911, and Title 26 CFR subsection 1.1-1C. The corrected alternative argument. This confusion results from a misunderstanding about the meaning of the word United States, which, like most other words, changes meanings based upon the context in which it is used. The term United States within the Constitution includes states of the Union and excludes federal territory, while the term United States within federal statute law includes federal territory and excludes states of the Union. People born within states of the Union are constitutional citizens of the United States of America under the 14th Amendment, but not statutory citizens of the United States under any federal statutes, including Title 8 U.S.C. subsection 1401, because the term United States has an entirely different meaning within the scope of the context. The most important aspect of tax liability is whether you are a member of the club, called the statutory citizen, who is therefore liable to pay club dues called taxes. The Constitution, in fact, establishes two separate clubs, or political and legal communities, each of which is separate from the other by what is called the separation of powers doctrine. One can only have a domicile in one of these two jurisdictions at a time, and therefore can be a taxpayer in only one of the two jurisdictions at a time. The U.S. Supreme Court admits this when it held the following. It is clear that Congress, as legislative body, exercises two species of legislative power, the one limited as to its objects, but extending all over the Union. The other, an absolute exclusive legislative power over the District of Columbia. preliminary inquiry in the case now before the court is by virtue of which of these authorities was the law in question passed. The main purpose of the separation of powers is to protect your constitutional rights or your constitutionally protected rights from covetous government prosecutors and judges who want to get into your back pocket and enlarge their retirement check. When we come back, we'll talk about unjust enrichment and how this all comes into play. Thank you for joining me. Gary Davis was a song and dance man on his way to becoming a success in show business until the U.S. entered World War II and he was drafted. He served as a fighter pilot, dropping bombs on Hitler. Yep, agreed. Yeah, very brilliant, Keith. Anyway, we'll get back to you guys here a little bit later. It's cigarette time, and I need a fresh cup of coffee. So we'll be talking to you real soon.